Welcome to the Supreme Court of the United Kingdom, where today we are beginning the hearing in the case of AB and the Secretary of State for Justice. The basic issue in the appeal is whether the treatment of a 15-year-old boy when he was detained at Feltham Young Offenders Institution violated the prohibition of inhuman and degrading treatment in Article 3 of the European Convention on Human Rights. He's referred to in these proceedings as AB in order to protect his identity in the interests of his own health and safety. The court has made an order requiring that no one shall publish or reveal his name or address or any information which would be likely to lead to his identification or that of any member of his family in connection with these proceedings. And I should explain that that order applies to members of the public using social media just as much as it applies to professional journalists. Anyone who is in any doubt about the effect of the order should consult the communications team at the Supreme Court, whose contact details can be found on our website. I'm hearing the appeal with four of my colleagues, whom I should introduce now. Lord Lloyd Jones.
Good morning.
Lord Sales.
Good morning.
Lord Hamblin. And Lord Stevens.
Good morning.
The appellant is represented in these proceedings by Mr. Squires, Queen Counsel, assisted by Ms. Christie. And I'll turn now to Mr. Squires and invite him to begin his submission.
Thank you. My Lords, there's two questions of law before you. The first, we say, is whether placing a child in solitary confinement is inherently inhuman or degrading treatment, so as to invariably breach Article 3 of the European Convention. The second question is, if not, is it at least treatment that requires detaining authorities to show that placing the child in solitary confinement is strictly necessary to protect the child or others? Does placing a child in solitary confinement have to be used exceptionally as a matter of last resort? We say they all mean essentially the same thing as strict necessity. So those, but as we said, are two legal questions before you. And I know we're sometimes discouraged from using Latin terms, but the best way we could think of to summarise the two issues is whether solitary confinement of children is per se degrading, so that it's simply prohibited by Article 3, or if not, is it prima facie degrading treatment, so that like restraint of a child or restraint of a patient, or as we'll see, seclusion of a patient, it may be lawful, but only if it's strictly necessary, otherwise it contravenes Article 3. My Lords, in terms of the issues which are and are not in dispute, we say that solitary confinement of children is at least prima facie degrading, so as to require the strict necessity test, and we go further than that and say it's per se degrading. The Secretary of State's position is that it's not per se degrading to subject children to solitary confinement. And as we'll see, that issue turns on the correctness of the parties' positions on the international treaty law. They're critical, the international treaties are critical to our argument on the per se degrading. The Secretary of State's position on the second issue, he says there is no strict necessity test, there's no strict necessity requirement that must be satisfied before a child is placed in solitary confinement. It's not, he says, in our language, prima facie degrading. And we say that's wrong, and we say it's wrong even on the Strasbourg authorities on the solitary confinement of adults. And it's certainly wrong, we say, on the Strasbourg authorities that have looked at restraint of patients, seclusion of patients, and things like that. We say it's supported, strongly supported by the international materials, but for the purpose of the second argument, we don't need those. A number of matters aren't in dispute, as we understand it, on the second issue, the strict necessity issue. The Secretary of State doesn't suggest that if a strict necessity exceptionality test is applicable, that was the test that was applied by the Court of Appeal or by Mr. Justice Ousley at first instance. He also doesn't say that if a strict necessity exceptionality test applied to AB's first 55 days in Feltham, it would have been satisfied. That's why that part of the case turns on what the applicable test is. And my lords will see that we said at paragraph 127 of our printed case, I only need to turn it up, but it's page 108 of the electronic bundle, that had that test, had the strict necessity exceptionality test applied, we said the court would have been bound to find it wasn't satisfied. And we then set out paragraphs 128 to 137 why we said that was so. I say the Secretary of State disputes the legal proposition, but doesn't dispute that if that was the correct test, it wasn't satisfied in this case. And that's because, we'll see very briefly, it's never been suggested that keeping AB locked alone in his cell for more than 23 hours a day without access to education, gym, other purposeful activities, a minimal of meaningful social interaction, i.e. his solitary confinement, it's never been said that that was strictly necessary. Indeed, as we'll see, it's clear that holding AB in those conditions was a breach of the Young Offender Institute rules, and that's never been disputed, and the Secretary of State has never sought to justify that, and nor has he appealed against the finding of Mr. Justice Ousley, specifically in relation to the requirement in the YOI rules for 15 hours a week of education, that wasn't provided because not enough thought, effort and resources have been put into it. That's paragraph 31. And so all of that, we say, explains why any suggestion that AB's solitary confinement was strictly necessary would have been fatal. We'll also see from the Strasbourg authorities, which have applied a strict necessity test in other contexts, but also the Strasbourg authorities on adult solitary confinement, that they've stressed the importance of procedural safeguards, even in the case of adults subject to solitary confinement, which, as we'll see, the Strasbourg jurisprudence certainly permits in exceptional circumstances. There's a stress on the need for procedural safeguards, and we'll also see that in a number of the international and domestic reports that have looked at separating children. And one of the things, and we do say that that's important, and we do say that in this case, one of the striking features was the absence of any procedural safeguards, the absence of anyone ultimately directing their mind to whether it was necessary to keep AB in the conditions which we say constitute solitary confinement for that period. And again, we'll see that when we turn to both the authorities, but also the facts of the case. In terms of the two issues, I say is solitary confinement children per se degrading? If not, is it prima facie degrading? Some of the material will be the same. It will be, we say, the issues before the court, or the matters the court will want to consider, will be the potential risks to and effects on children of being held in solitary confinement, locked alone in the cell for more than 23 hours a day. Also relevant to both issues will be what the various international and domestic bodies have said, and relevant to both issues, though only critical, we say, to the first issue, the per se degrading treatment, will be how unincorporated treaties are to be applied when interpreting Article 3 in this context. Beyond that, however, I say the strict necessity argument is a different one, and it does depend, and I'll take you through the various relevant Strasbourg authorities that apply a strict necessity test, exceptionality test in these or certainly very similar cases. Well, finally, by way of introduction, I was intending in my oral submissions to deal with the matters that are covered by both grounds of the appeal first, but then to deal first, if I may, with the second ground, with the strict necessity argument. I hope that enables me to deal with the materials more efficiently. Secondly, of course, if I can't satisfy you on a strict necessity exceptionality argument, obviously won't satisfy you on the higher completely prohibitive hurdle. But the third reason I was intending to do that is I hope it'll provide a shortcut to a number of the Secretary of State's arguments, because on ground one, the Secretary of State's key submission, or one of his key responses, is he says, this is in paragraph 3 of his printed case, that we're inviting the court to go well beyond the Strasbourg jurisprudence on the use of solitary confinement and departing from what he says is the intensely fact-sensitive inquiry in relation to Article 3. We respectfully don't accept that submission in relation to our ground one, the per se degrading treatment, and we'll see why we say we can get that from the Strasbourg authorities read with international treaties. But in any event, the argument about the fact-sensitive inquiry going beyond the Strasbourg jurisprudence doesn't apply and isn't said to apply to the second argument, the prima facie degrading treatment argument. Firstly, it is a fact-sensitive test, as I think the Secretary of State accepts the strict necessity test. And secondly, our submission will be that it doesn't go in any sense beyond what Strasbourg has held. Indeed, it fits fairly squarely into what Strasbourg has said about adult solitary confinement. But certainly, if one looks at what Strasbourg has said about other vulnerable groups, in particular patients, what it said more generally about children, we say it fits squarely within that line of jurisprudence. Well, that's all I was going to say by way of introduction. I was going to deal very briefly with the factual background and just 2 points which will tie into the submissions I'll make later. One about the meaning of solitary confinement, and the second about the issue I've already highlighted, the procedural safeguards that Strasbourg regards as so important in this context. We're concerned with the first 55 days of AB's time at Feltham, from the 10th of December 2016, when he arrived, when he was age 15, up until the 2nd of February 2016. And my lords, will see there is a dispute as to whether solitary confinement of children is prohibited in international law. There's a dispute about if it is, about what the consequences are for interpreting Article 3. And there's also some dispute about whether there is or isn't now a relatively well-established definition of solitary confinement. But what our submission is that it's clear, and it doesn't appear to be disputed, is that on any definition of solitary confinement that's been given, whether one's looking at the authorities that have considered solitary confinement in Strasbourg or domestically, or the various bodies that have defined it, on any definition, AB was kept in conditions of solitary confinement for much or all of that first 55-day period at Feltham. And if I may, just to see what those conditions are, I'll do it very briefly by reference to AB's witness statement. So you see it in his words. You may well have had a chance to look at this, but it's at page 621 of the electronic bundle. There's a handwritten copy as well, a few pages before, from his instructing solicitor as he dictated it. But this is his statement. So it's written on the 9th of February. So in fact, it's a week after the period we're concerned with. but he described essentially the regime he's subject to. And you'll see it's short, and what he says in paragraph 1, he explains he's been on something called single unlock since the time he arrived at Feltham. What that means is that he's not allowed to be unlocked at the same time as any other child. And we'll see in a moment that consideration was given to keeping him separate from other children, which, as we'll see in a moment, is quite distinct from solitary confinement. But that was the decision to place him in single unlock. And you'll then see paragraph 2, a description, 2, 3, 4, description of his day. He's taken about 10, 20 minutes to get his medication. Ren is the wing where the medical centre is. He then gets, paragraph 2, then I either get my 30 minutes time out on the landing. I think there's what it should say is either get my 30 minutes on the landing or outside. Essentially, he has 30 minutes. And during that time, he's either on the landing, in which case he can make shower or phone call, or he goes onto the exercise yard on his own. And as we'll see later on in the statement, he doesn't have time to do both. So he essentially chooses between shower and phone call or getting out. And then he says, then I'm banged up for the rest of the day. He then says, lunch is brought. He says, sometimes if he can't get through on the phone, he's locked up earlier than the 30 minutes and then maybe allowed out later on to call. Lunch at 11:45, dinner 4:30. And then in paragraph 5, all I can do is watch TV. I don't read, that's boring. I don't have any books. When I'm in my cell in the evenings and the other kids are on association, they always turn a power, so I can't even watch TV. He then explains he doesn't do any education. At this stage, you see it's the 9th of February, so he's already had 2 sessions from something called Kinetic, which starts on the 2nd of February, which I'll come back to. The chaplain sometimes knocks on the door. I want to do education. Paragraph 8, I'm in year 11. I want to do my GCSEs. And then paragraph 12, he just describes in his own words what it felt like being on my own the whole time is boring. All I do is lie on my bed and watch telly. Sometimes I have bad dreams. I feel tired from not being motivated, not doing nothing. I'm not getting enough fresh air because not long enough to do a shower and phone call and exercise. That's what you saw from paragraph 2. He ultimately has to choose whether he's on the landing, which is shower and phone call, or outside, which is his exercise. My lords, I won't take you to it, but if you want a sketch of what the cell would have looked like, or what a typical cell would have looked like, it's in tab 48 of the supplementary authorities at page 3948. And what you'll see there is that the cells roughly it's a little under 6 foot wide and a little over 11 foot in length. It has a bed in it, a table, a television, and a toilet. And essentially, those were his conditions of detention for the first 55 days, other than, you'll see we set out at paragraph 65 of our printed case. He has a number of, I think about 10 or 11 occasions listed over those 55 days of someone coming to see him. It might be a social services assessment or a visit from the chaplain. But other than that, essentially, his days are 10, 20 minutes out when he's taken to get his medication, 30 minutes either for exercise in the exercise yard or shower and phone call. And the rest of the day, he has nothing to do but sit in his room and watch television. And those essentially were the conditions found by Mr. Justice Ouseley. It's paragraph 133 of his judgment. What Mr. Justice Ouseley found is that there were some days where he would be in his cell for 23 and a half hours, but he said routinely it would be 23 hours a day. And he said he certainly found, we'll see why when we look at the definition of solitary confinement, that there would have been periods for more than 15 days, 15-day stretches when he was certainly in his cell for more than 22 hours a day. The second point I want to make about the factual material, and as I highlighted this about the role of safeguards in the strict necessity jurisprudence. the reason that AB was placed on single unlock, i.e. not allowed to meet with other boys, was initially so that an assessment, his behaviour could be assessed. We see that from page 747 of the electronic bundle. But after that initial period, it was to protect him from other boys, because what happened is he would shout abuse at other boys through his cell doors. And you'll see from our printed case that a lot of that was to do with his relatively serious mental health problems and the way that he would react to feeling threatened. But that did lead to threats to him from other boys, and a decision that he wasn't able to associate with other children out of his cell. But what is also clear is that at no stage, certainly there's no documentary evidence, no indication of any meetings. Does anyone sit down and think, does he need to be in his cell for more than 23 hours a day? Does he need to be deprived of education, any other purposeful activity, meaningful interactions with adults? That changes. And the reason that the 2nd of February is the cut-off point, because on the 19th of January 2017, the Howard League wrote to the YJB, the Youth Justice Board, the interested party in this case, and you have that email at page 560 of the electronic bundle. They'd been contacted the day before by AB, and they wrote expressing concern that he appeared to be being held in conditions of solitary confinement. The next day, someone from the YJB visited Feltham, the 648 of the electronic bundle, and instructed Feltham to hold an MDM, a multidisciplinary meeting. That's then held on the 24th of January, and that's the first indication of any meeting, conscious thought being given to whether AB needed to be held in those kinds of conditions, not simply did he need to be separated from other boys, but did he really need to be locked in his cell for that much of the day? And you'll see, if you look at the minutes of the meeting, and again, I won't take you to them, they're 652 and 721, they appear in two places. It is clear that at that meeting, which is attended by AB's senior officer, someone from psychology, someone from the youth offender team, as well as someone from the YJB, it becomes clear at that meeting that he's not receiving education, any gym. He says he wants to be provided with education. He says he wants to be able to go to the gym. And shortly thereafter, measures are put in place that get him out of his cell, generally speaking, certainly for more than an hour a day. And that's when the kinetic provision starts, the kind of life skills program.
Could you just give me that page reference again, please?
Yes, it's 652.
Thank you.
And there's another version, 721. There's slightly different sets of minutes to the 24th of January meeting, MDM.
Yes.
And it's particularly one we see at the first page, there's the discussion when he says, I'd like to do education, or want to do maths and English, I think he says. And the senior officer says, well, I'll pass that on to education and see what we can do. Same with the gym. And then from the 2nd of February, measures start to be put in place. So the kinetic and kind of life skills training, he starts to get that occasionally from the 2nd of February. He starts to get education in maths and English from the 16th of February. 21st of February, he's able to go to the gym. And in March, he starts with some psychology sessions. Now, those are far below the statutory minimum required by the Young Offender Institute rules, but it does mean, and certainly meant by the time of the hearing before Mr. Justice Ousby, that he was getting out of his cell relatively regularly for more than 2 hours a day. He had meaningful activities, meaningful social interactions with other people, not with children, but with adults in education or kinetic or wherever it was. My Lords, turning to my second topic, which is the meaning of solitary confinement. We'll see there's a number of reports now, various international and domestic bodies that have produced a definition of solitary confinement. There's also a series of authorities that have discussed solitary confinement, both domestically and in Strasbourg, which both parties rely on. And as we'll see in a moment, since 2011, at least, since the Special Rapporteur, the UN Special Rapporteur, produced a definition of solitary confinement in a report, which is unfortunately cited in Borgas, most of the international bodies, and certainly the domestic bodies, use a particular definition, which I'll come to. I'd say the courts, where they've used the phrase, haven't always defined what they mean by solitary confinement. But as I said earlier, under any definition of solitary confinement which has been produced, AB's detention would fit within that. Indeed, his conditions of detention were pretty similar, if not slightly harsher than those applied in Borgas and described by the Supreme Court there as solitary confinement. I think Borgas had an hour out of his cell each day. And the reason it's clearly solitary confinement, or perhaps I could say that through a negative, is that what solitary confinement doesn't mean, as anyone uses it, is total solitary confinement, which is a phrase that's used in some of the case law. It doesn't require a prisoner to be locked up for 24 hours a day with no human contact at all. Indeed, it's not clear anyone, adult or child, could survive very long in that way. What all of the definitions of solitary confinement, in one way or another, are getting at is someone being held for the very significant majority of their day alone in a cell and with very limited meaningful human interaction. And that clearly fits, we say, with the way in which AB was held, certainly for that first 55-day period. In terms of definition, if I want some more concrete definition of solitary confinement, I say most of the authorities haven't really discussed it. You'll see in paragraph 4 of our printed case that we set out the definition used by the National Preventative Mechanism in one of its reports. And we then set out paragraphs 4 and 5 of our printed case, briefly the genesis of that definition. As I say, it starts with paragraph 5, something called the Istanbul Statement, which was an influential symposium in 2007, whose findings were quoted in Borgas. It's then used by the Special Rapporteur, UN Special Rapporteur on Torture in 2011. At that time, he said there is no universally agreed upon definition, but he produces a definition which reflects the one from the Istanbul Statement, which is over 22 hours, confined alone in a cell with minimal meaningful human interaction. Essentially, that's the definition. And you'll see there, we list all the different bodies that have since then used that particular definition of solitary confinement. And our submission is it may not matter, be critical for the purpose of this case, exactly what definition one chooses, because, as we say, it's quite clear in our submission under any definition this was solitary confinement. But it may assist at least the discussion to use that definition, at least when considering what all these different international and domestic bodies have said, because it means one is talking about the same phenomenon. As I say, it's not total solitary confinement on the one hand. It is also not, on the other hand, if I can put it that way, the same as removing a child from association or separating a child, as the term is sometimes called. We set that out in paragraphs 7 to 8 of our printed case. Under the Young Offender Institute rules, Rule 49, children can be removed from association, i.e. not allowed to interact with other children, separated from other children. That is not solitary confinement. It's permitted under the YOI rules. Solitary confinement, I say, leaving a child locked alone in a cell for over 22, 23 hours a day, minimal meaningful contact, is a quite different phenomenon. And that is something that is prohibited by the YOI rules, or certainly if the YOI rules are complied with, a child cannot be held in solitary confinement. You have the YOI rules in tab 1 of the authorities manual. I won't ask you to turn them up, but just for my Lord's note, Rule 38.2 requires children of compulsory school age, such as AB was at the time, to be provided with 15 hours a week of education. That's at page 967 of the bundle. 41.2 required them to be provided with at least 2 hours a week of physical education. And rules 3 and 37, when read together, provide that a child has to be occupied with a programme of activities that includes education, training courses, work and physical education. And that programme, says Rule 3, should be designed to assist the offender to develop or acquire personal responsibility, self-discipline, physical fitness and skill, and to obtain suitable employment after release. So if detaining authorities comply with the YOI rules, a prisoner cannot be held in solitary confinement. They'll be getting out of their cell, engaging in meaningful activities, certainly more than 2 hours a day. And that's why we do say the distinction between solitary confinement and simply separating children is critical. And it's also critical, as we'll see, from all of the different bodies that have considered solitary confinement of children. All of them say that there may be circumstances where it's necessary to separate children, to keep children apart. And it may well have been, in this case, given what Feltham says to be the threat AB face. But none of them say it is lawful, or perhaps another way, given they're making recommendations, none of them say it's acceptable to place a child in solitary confinement. Can I turn next to those various international and domestic materials that have dealt with solitary confinement? You'll see in our printed case that we've set out paragraphs 42 to 44, what the UN Committee on the Rights of the Child said about it, the UN Committee Against Torture at 45, 2 General Assembly resolutions at 47, that's the 1990 UN rules for the protection of juveniles, and then the Mandela, what someone's called the Mandela Rules, 2015, both General Assembly resolutions. What the UN Special Rapporteur says is at 12 to 13 and paragraph 48 of our printed case. And what the European Committee for the Prevention of Torture, often known as the CPT, said after a visit to Hook and Wood Young Offenders Institute in April 2017, we've set out 49 to 50. We also set out 9 to 21 what a series of domestic and more general medical bodies have said about solitary confinement of children. I wasn't intending to take you through any of those materials, save for the ones related to international treaties, because in relation to the rest of the material, there's a dispute as to their legal significance, but not, as I understand it, as to what they say. What I was intending to do, if I may, is simply to give you some page references. I think it works out about 30 pages in total, which we would ask the court, if it would, to read, but not immediately, and to give you what we say are the key points that come out of each of those reports. So starting with the international statements, and so I'll come back to the treaty law point shortly, but starting with the international bodies that consider the matter. The first is the Istanbul Statement, as I said, in 2007, and that it may help just to read the whole document. It's only 4 pages. It's at 1013 to 1017. It sets out at 1013 the definition that became influential. 1014, it sets out the effects of solitary confinement, which were quoted by the Supreme Court in Borgas. And then it sets out its conclusion, which is that solitary confinement, this is 1016-7, can be permissible for adults, but should be kept to a minimum. For adults, the Istanbul Statement considered that solitary confinement should be used in very exceptional cases for as short a time as possible and only as a last resort. And it considered that it should be prohibited, never used for children. Special Rapporteur report is at, I should say that's at tab 4 of the primary authorities. Tab
I'm sorry, where do you find the discussion of children?
it's 1016. Because I think there's a list of
Yes, I see.
Special Rapporteur's report is at tab 38 of the primary authorities bundle, page 2174. He sets out the pages or the parts to read will be paragraphs 25 to 26, where he sets out the definition, page 2181. Paragraph 62 to 65, he sets out what's known about the psychological and physiological effects of solitary confinement and its latent effects. And again, some of this was referred to by Supreme Court in Borgas. And then 79 to 101 paragraphs, pages 294 to 2194 to 2198, is his conclusions and recommendations. And he concludes 81 and 86 should never be used for children. And again, we'll see this pattern emerging for adults. 88 and 89 he says, may be a legitimate device. He says, provided adequate safeguards are in place, but he says, should be used only in very exceptional circumstances as a last resort for a shorter time possible. That's 89. And again, repeats the importance of procedural safeguards in the adult context. And 94 to 97 explains what he means by those procedural safeguards.
Can I ask, do you happen to know who the Special Rapporteur was at that time?
I think it was Mendes, but we'll check. I think it's Juan Mendes, but we'll check. Third international body is the CPT. So it reported April 2017 following a visit to the UK in March or April 2016, and it visited a Young Offenders Institute at Cookham Wood, so a different one. And you have that at tab 33 of the authorities. And there we'd ask you to read pages 2014 to 2018 of the electronic bundle, particularly paragraphs 91 to 93 and 96 to 98. At 91 to 93, a CPT describes the position of a significant number of boys at Cookham Wood who were in regimes that are essentially identical to the one that AB was subject to, which is unlocked for around 30 minutes a day without access to education or other activities. They were placed on what was called a separation list because they'd been violent or for their own protection. And the CPT described one boy who'd been in those conditions for several weeks, lying on his bed under his covers, blankly looking at the TV, and it concluded it thought that was inhuman and degrading treatment. And later on, it gave recommendations, including that children should never be placed in solitary confinement, including for good order and discipline. Yeah, but I'm told it was Mendes who was Juan Mendes who was the special rapporteur. Turning to the domestic bodies, the first two reports are inspection reports of Her Majesty's Chief Inspector of Prisons. First in 2015, which you have at tab 34, and there we just ask you to look at pages 2027 to 2028 of the electronic bundle. And there the Chief Inspector records boys at Feltham spending more than 22 hours a day in restricted regimes where they were denied access to activities. He describes that as, in effect, solitary confinement on their residential units. And he found at that time that 26% of the boys were being held in those conditions at Feltham. He then did a conduct report specifically of Feltham, which you have at tab 35, during the period AB was there. So and indeed during the period that we're concerned with. So he conducted an inspection 23rd of January to the 3rd of February 2017. And we just asked you to look at page 2038, which sets out the general concerns that the inspector had about the conditions at Feltham, and particularly the use of such restricted regimes. And then paragraphs 1.53 to 1.54, that's 2060, and 3.1 to 3.3 at 2078. And there, again, he described boys exhibiting violent behaviour, being placed on a restricted regime without access to education, work or worship, unlocked for less than an hour a day. So it's a description, essentially, AB was one of those boys, and found that that was more than a quarter of the boys at Feltham at that time. 3.1, 3.3, that is described as unacceptable by the Chief Inspector. And he also expressed 3.3 significant concerns about boys, some of them only having 10 minutes in the fresh air each day.
It occurs to me that you understandably want to address us particularly about the significance of reports by the committee responsible for oversight of the operation of the UNCRC. But it occurs to me that the CPT is a Council of Europe body, which is, when it talks about inhuman and degrading treatment, it's talking about Article 3. It would be interesting to know what significance the court has attached to CPT reports in its case law.
Well, yes, I'll certainly be addressing on that. I put them under the bracket of soft international law, in the sense that these are just recommendations, unlike international treaties. But I will be addressing you both on how hard international law the international treaties treated. But also,
when the CPT reported that holding juvenile inmates in the conditions it found at Cookham Wood amounted to inhuman and degrading treatment, that wasn't a recommendation in a sense, when that was a finding. Now, it's obviously not a finding by the court, but that's why I'm raising the question: what weight is given to CPT reports by the court?
I'll certainly come to that. We haven't found, and we'll see when we go through the case on, I'll give you a few examples, that CPT reports are routinely cited by the court in order to give a sense of what the European view is, whether there's a European consensus. I haven't found a CPT report, or we haven't identified one, which makes a finding that close to being a finding of breach of Article 3. So I don't know, what we don't know is how the European Court would deal with that. But we would say that given the weight they tend to attach to the CPT, at least to showing what the consensus is or what the concerns are, even though, as I say, the CPT is not making legal findings in that sense. Our submission would be that certainly weight would be attached to that being the reaction of the CPT to seeing someone held in those conditions.
Yeah, well, obviously, it's not legally finding on anybody. But it's made a finding at page 2015 about the compatibility of conditions in which children were being held at Cookham Wood with Article 3, as I read it.
Well, yes, so that's how we read it. Yes, and our submission would be that is something that, look at the way the Strasbourg jurisprudence looks at other CPT reports, they would certainly give weight to, at least as a factual finding. by the CPT, how it responded to that, those kinds of conditions. Well, that was the chief inspector. Then briefly, just to give the references to the other reports, there's the National Preventative Mechanism report. You have at tab 36, page EF 2102, and there we'd ask if we may to look at 2118 to 2119, which is the definition of solitary confinement, and also the definition of something different, which is described as isolation. And then 2127 to 2132, and there the National Preventative Mechanism 2131 to 2132 and also 2129 first expresses concerns about a lack of procedural safeguards, about informal, what described as informal practices that lead to solitary confinement. And it then gives at 2131 its view that children should never be held in conditions that amount to solitary confinement, expresses concerns about children having not developed cognitively, mentally or emotionally. It says the possibility that isolation or solitary confinement could cause lasting harm cannot be dismissed. And its conclusion is that children should never be held in conditions of solitary confinement. I should say the NPM is the body charged with overseeing all of the different detention facilities. It's chaired by the Chief Inspector of Prison, but it also oversees any facility where people are detained, and it reports under the Convention Against Torture on the UK's compliance with that convention.
This is a body. I'm just looking at the introduction to the document. It rather looks as though this is a body designated by the government in order to comply with a requirement of an international treaty, the optional protocol to the convention, the Torture Convention.
Yeah, yes, precisely. Yes, under the Torture Convention, we're obliged to inspect any places where people are detained, and this is the body. I think it was from 2009. I think it was said by part. This is the body that fulfils our obligation. So it's an umbrella body that looks at all places of detention.
Right.
The supplementary authorities. Tab 53 is the JCHR, the Joint Committee on Human Rights report from 2019. 4018, again, sets out the same definition of solitary confinement and separation, and it calls on the government to cease to hold children in solitary confinement. 4023 to 4026 is some evidence that it hears about the effects of solitary confinement on children. And there's also a concern, this comes back to the procedural safeguards, that it expresses about separation, being able to drifting into solitary confinement. It says that it recognises, and we accept there isn't a government policy on placing children in solitary confinement, but with a lack of procedural safeguards, separation of children can drift into solitary confinement. Next is the British Medical Association, Royal College of Psychiatrists, Royal College of Paediatricians and Child Health. It's a one-page statement, tab 30, page 1982. Again, they use the same definition of solitary confinement. They express concern about the medical evidence of the effect of solitary confinement on children at the particular stage of their development, and it calls on solitary confinement to be prohibited for children. And then finally, the two reports from the Children's Commissioner, tab 31 and tab 32. And there, if we ask you to read, again, you'll see the same definition, 1987 of solitary confinement, paragraph 12.3 of the first report, about concerns about how solitary confinement, indeed isolation of children, can be counterproductive. And then in the second report, tab 32, October 2018, pages 2001 to 2007. And again, it's the same set of concerns about children being kept in conditions of solitary confinement. And was on submission. I'll come in a moment to the legal significance of those various documents, and it may depend in part whether they're international bodies such as CPT or domestic bodies. But what we do say about all of those bodies is they say strikingly similar things. Firstly, what's notable that none of them say that solitary confinement of adults should be absolutely prohibited. Those who've expressed opinions say it should be kept at a minimum, very exceptional circumstances, procedural safeguards, but none say it should be prohibited. Secondly, none of them say children should never be separated from other children. Again, it's recognised that may be necessary in some cases. Again, the ones that have considered it have stressed the importance of procedural safeguards to make sure separation doesn't become solitary confinement, but they all accept it may be necessary. Third, all of them that give an express definition of solitary confinement use essentially the same definition, the 22 plus hours, etc. Fourth, most importantly for our purposes, all of them say that solitary confinement children should be prohibited. So there's a range of international and domestic bodies charged with conditions of detention, children's rights, health bodies. All of them reach the same conclusion, which is that it is never acceptable to hold children in conditions of solitary confinement. I say that includes bodies that inspect prisons in the UK. And other than one report, which I'll come to in a moment, identified by the Secretary of State, no one has suggested any other body, any other expert who has ever said that solitary confinement of children can in any circumstances be acceptable. And indeed, there isn't evidence from the Secretary of State, from MOJ officials, witnesses, people who work at young offenders institutes who say this is a practice which can in certain circumstances be acceptable. The only body, as I say, that has suggested it may be acceptable to hold children in solitary confinement that's identified by the Secretary of State is a CPT report from 2015. And it may be helpful to turn that up. So we say two things about that report, and we'll see what it says in a moment. The first thing, of course, this is the CPT you have a report in the Supplementary Authority Bundle tabs. It's in twice, but tabs 45 and 46, but tab 45 is probably the clearest. And we'll see in a moment that says that in some circumstances, solitary confinement children may be acceptable. We say two things about that. First, of course, the following year, 2016, the CPT inspects Cook and Wood. 2017, it produced its report, and it there says children should not be held in solitary confinement under any circumstances. So whatever it thought in 2015, it seems its views had changed. But also importantly, if one looks at what it says, the CPT in 2015, what it calls for is pretty much identical to the strict necessity test that we say is applicable. I say you have it, page 3905 of the Authorities, tab 45. I say this is the one suggestion that it might be acceptable to hold children in solitary confinement. Paragraphs 128 and 129 are relied on by the Secretary of State.
Can I have the page again, please?
3905.
Thank you.
And if you have 128 to 129, it said if used as a disciplinary measure, should only ever be for 3 days, under no circumstances more than 3 days. And then 129, which the Secretary of State relies on in his printed case, he says, well, look, there's no limit if you use solitary confinement for other purposes to protect vulnerable juveniles or to prevent serious risks. As I say, this is the only report that's ever suggested that, but you can also see what it says, which we say strongly supports the strict necessity argument. Such a measure may in extremely rare cases be required protect particularly vulnerable, provided that absolutely no other solution can be found, and then the stress on procedural safeguards, which is another feature we see repeated in the different recommendations. So our submission is there is certainly now a clear consensus of domestic and international bodies that say that solitary confinement of children should be absolutely prohibited. And I'll come on to the legal significance of that in a moment. But I want to make submissions more generally about how we say the international materials ought to be dealt with by the domestic courts. And that depends, we say, on whether one's dealing with binding international law at the international level, so obviously not binding domestically, so these are unincorporated treaties. They're approached in a particular way in the Strasbourg and domestic jurisprudence, and they're treated differently from the various different recommendations of expert bodies. And our submission that the relevant hard international law treaties to which the UK is a signatory that are relevant are the UN Convention on the Rights of the Child and the UN Convention Against Torture. And we accept, and it's never been disputed, they're not binding domestically. But it's also not disputed that there are circumstances in which the domestic courts can and should take account of the requirements of international treaties in interpreting the European Convention on Human Rights. And we say that the position is this, that where the courts are interpreting provisions of the ECHR and there are relevant requirements, we do underline that, imposed by other international treaties, and in particular human rights treaties, those requirements, quote, must be taken into account in interpreting the European Convention on Human Rights. And of course, the international law requirement has to be relevant, and the role of the domestic court is to decide what the international law requirement is, with the aid, as we'll see, of other bodies who've considered it, and whether it's relevant to the interpretation of the convention. If it is, then it needs to take it into account. Again, it doesn't mean it's bound by the international law position to find that the convention imposes exactly the same requirements, but it is obliged to take it into account. Well, I hope that isn't a controversial statement. It's been repeatedly held to be the case, and I don't think it's disputed by the Secretary of State. You'll see in our printed case at 88 and 89, we quote from the various authorities. It's Newlinger onwards and the way in which that has been applied by the domestic courts. It's applied in ZH in Tanzania, it's applied paragraph 21, it's applied in DA, paragraph 71, and Demir is applied in the C case by Lord Justice Leggett, as he then was, which you have at page 1221, the paragraphs 97. I won't take you to those, we don't think it's controversial. They all make the same point, which is, and it's all quoted from Demir and Newlinger, which is that if there are relevant international law provisions, and if there are relevant comments from the bodies that monitor those provisions, they have to be taken into account when interpreting convention rights. So the question is, are there relevant? And this seems to be the dispute, and certainly it was what the Court of Appeal found. The Court of Appeal found there weren't any relevant international treaty provisions. And we rely on, as I say, the Convention on the Rights of the Child and UNCAT, and the provisions we rely on in the UN Convention on the Rights of the Child are 37A and C, which you have in tab 5, page 1020. And we'll also see that 37A is a provision very similar to Article 3 of the Convention. No child will be subject to torture or other cruel, inhuman or degrading treatment or punishment. and then provisions about capital punishment that don't concern us. And then C, every child deprived of liberty shall be treated with humanity and respect for the inherent dignity of the human person, and in a manner which takes into account the needs of persons of their age. And 37C is going to be of particular importance in our case, because as we'll see, it's that which the Committee on the Rights of the Child has applied. It's in the interpretation of what that requires. The Committee on the Rights of the Child has discussed the solitary confinement of children. Also relevant, or the other international law provision that's relevant, is Article 16 of UNCAT, the UN Convention Against Torture, which is at tab 7 of the supplementary authorities, page 2263. I don't think you need to turn it up, but essentially it prohibits or requires states to prevent in their territory acts of cruel, inhuman or degrading treatment by public officials. So again, it mirrors the language of Article 3. The Secretary of State deals with the UN, what the UNCRC says, and the UN Convention on the Rights of the Child, and by extension what UNCAT says at paragraphs 55 to 69 of his printed case, page 141 of the bundle. And he says at paragraph 61 to 69 deal with the views of the Committee on the Rights of the Child. I'll come to that in a moment. I just want to deal with what he says, paragraphs 56 to 61. First, it said that the UNCRC is not directly incorporated. We accept that. It's not binding. We've never said otherwise. What he then says at paragraph 57, he says that the language of Article 37 adds nothing to the interpretation of Article 3 in this context. Then over the page, he then notes that it says nothing about, second point, it says nothing about solitary confinement of children in Article 37, which we accept. Third, he says at paragraph 58, that article, we'll be presuming talking about Article 37A here, he says when two treaty provisions are for all material purposes equivalent, they can't be used to interpret one another. So we assume he's referring then to 37A, which prohibits cruel and inhuman degrading treatment of children, which obviously mirrors the language of Article 3 of the Convention. But what we say in response to that is, firstly, Article 37A may be written in terms that mirror Article 3, cruel and inhuman degrading treatment, but Article 37C is not. That focuses on treating children with respect to their inherent dignity. And as we'll see, that is the provision that the CRC, the committee, has applied to solitary confinement. And it's also 37C that's been used in other contexts to interpret Article 3 of the Convention. We'll see that in relation to restraint of children in the C case, C in the Secretary of State of Justice. It was also almost identical. It was a committee report about 37C about when restraint could be used on children. And that was used by the Court of Appeal to interpret Article 3. Second, our submission is that it is not dispositive that Article 37, or indeed UNCAT Article 16, do not refer in terms to the solitary confinement of children. Because what a treaty requires comes from interpretation of the words of the treaty, not simply reading the words and seeing if it refers to solitary confinement. For example, the European Convention on Human Rights doesn't anywhere say where there's an arguable breach of Article 3, states must conduct a prompt, independent and effective investigation, but it's now very well established that is a requirement of Article 3. And similarly, Article 37C of the UN Convention on the Rights of the Child doesn't say deliberate infliction of pain on children is not permitted, but that is how it's been interpreted by the CRC, and in turn that has been used, certainly by the domestic courts, to interpret Article 3. Third, no authority cited for the proposition that if you've got two similarly or identically worded provisions in different international treaties, they can't be used to interpret one another. And we say that's wrong in principle. We'll turn in a moment to what take into account means, or what the requirement is to read in harmony the different international law provisions. And we say if one international treaty has been interpreted as imposing a certain set of requirements within its understanding of cruel, inhuman and degrading treatment, it will be inconsistent with a requirement to read in harmony different international treaties to interpret another treaty imposing exactly the same restriction in some different way. So the fact they're worded the same way, if anything, suggests that if one has been interpreted in one way, one should at least consider whether to interpret the other provision in the same way to avoid, in the words I think used by the Secretary of State in this case, fragmentation and conflict. The question then is, what do the UN Convention on the Rights of the Child and the UN Convention Against Torture require? Do they impose any requirement of international law that is relevant to this case? And it's here that the views of the committee, both the Committee on the Rights of the Child and the Committee Against Torture, become critical. What the Secretary of State says about our case, this is at paragraph 55 of his printer case, he says that our case is that general comment in this case, number 24, and all the committee periodic reports constitute binding international law, and that its interpretation of Article 37 of the UN Convention must be followed by the domestic law. That's how he describes our case, paragraph 55. That isn't our case, and has never been our case. We don't say that the views of the committee constitute binding international law, nor do we say that its views must be followed. Our submission is this: the UN Convention on the Rights of the Child and the UN Convention Against Torture are treaties binding as a matter of international law, one. Two, as to what they require, one doesn't only look at their text, one also looks at the views of the relevant committees, and those committees, it's now well established in the domestic courts, give the authoritative or the most authoritative view on what the treaties require. So that doesn't mean that the views of the committee are in themselves binding, internationally or domestically, in the sense that a court decision is binding. But the treaty requirements are binding, and the committee gives the most authoritative view on what those requirements are. And I don't think that is seriously in dispute. Indeed, the Secretary of State cites the same authorities which describe the committee's views as authoritative, most authoritative. We set them out at 91 to 92 of our printed case. It's Williamson, SG, Matthias and DA.
They're all, I think, either Lady Hale or Lord Wilson.
I think it's Lord Calmworth in SG who describes the committee as the most authoritative guidance, but then I think Lord Wilson then subsequently agreed. But I think there's a dispute between the parties that is, I say, it's not authority in the sense of a court authority. It is the most authoritative view on what's required. And what that means, as I say, is it's not binding authority. The court can certainly say, the domestic court can certainly say, we do not accept that the committee is right in this instance as to what the relevant convention requires of member states. We do say in relation to that, our respectful submission is there has to be some reason for the court to think that the committee has got it wrong. If the committee is giving the most authoritative view, it may have got it wrong, but our respectful submission is the domestic court should at least have a basis for saying that's not the correct understanding of the treaty. And you can see an example of that happening in the Jones case, which is Jones of the Ministry of Interior of Saudi Arabia, which you have at tab 16 of the Primary Authorities File. And in that case, it's not the UN Convention on Rights of the Child, it's UNCAT that's relevant. And it was about immunity, whether Saudi officials, rather than the Saudi government, were immune from civil suits alleging torture. And in that case, there was a comment expressed by the UN Committee Against Torture in a report about Canada, which the House of Lords considered and held simply got the law wrong. And you can see the reasons for that most clearly in Lord Hoffman's speech at 56 to 58. The details don't matter. But you'll see he explains why he thinks this report about Canada is incorrect, misunderstood international, and he explains what he thinks the committee has misunderstood in reaching the conclusion that it did. So we do say, certainly if the court considers that the committee has got the law wrong or got the international requirement wrong, it certainly doesn't need to follow it. But we do say if it is the most authoritative view, there needs to be some reason for departing from it. My Lord, I see the time. I was about to turn to what the CRC says. I don't know if this would be a convenient place to have the 5-minute break I was told to stop for.
Yes, if that's difficult for you, Mr. Squires, we'll adjourn now for 5 minutes. Thank you. I think we're ready to resume now. Mr. Squires.
My Lords, I'm grateful. I was going to turn to what the Committee on the Rights of the Child and the Committee Against Torture have said about the solitary confinement of children. But it may help to deal with that by reference to what the Court of Appeals said about them, because it found that certainly the Committee on the Rights of the Child had not said anything relevant about solitary confinement of children for the purpose of this case. Paragraphs 76 to 77 of the Court of Appeals judgment, page 205, deals with general comment number 10. We'll see in a moment that's actually been superseded by general comment number 24, but the Secretary of State at least made some similar comments about the new general comment. General comment number 10, if the court has it, you'll see what the committee had said then in 2007. And the Court of Appeals conclusion at 77 is that it has no relevance, said, because that was about solitary confinement of children used as a punishment. And it went on to say similar things, paragraphs 101 to 106, about some General Assembly resolutions, the 1990 resolution and the Mandela rules, which also refer to the prohibition on the solitary confinement of children. But 105, according to the Court of Appeal, it only relates to disciplinary measures. What the General Assembly resolution says is all disciplinary measures constituting cruel, inhuman, or degrading treatment shall be strictly prohibited. This is in relation to children, including corporal punishment, placement in a dark cell, closed or solitary confinement, or any other punishment. And the Court of Appeal's view is that none of this was relevant because it says they're only talking about solitary confinement used as punishment. And our respectful submission is that that's not a correct reading of those reports. It's not stated solitary confinement, if used as a disciplinary measure, constitutes cruel, inhuman, degrading treatment. What it says is it describes those measures as constituting inhuman and degrading treatment, and then says they shall be prohibited as punishment. And certainly, which suggests that it's because they're cruel, inhuman, and degrading that they shouldn't be used as punishment. And we'll see when we look at General Comment 24 that it is quite clear that is what the committee meant by this. And certainly that's how the committee itself interpreted it. And we can see that from the observations it made about the UK's compliance with the Convention on the Rights of the Child. And that's dealt with by the Court of Appeal at paragraphs 93 to 96. And maybe just to see what's said from the Court of Appeal's judgment. 78G is paragraph 94 of the report. It notes that segregation in soothing solitary confinement is sometimes used for children in custody, including in young offenders' use. Now, by definition, that cannot be for punishment because solitary confinement cannot be used for children in YOI in young offender institutes. That's prohibited by the YOI rules. It then states, 79, as the Court of Appeal notes, with reference to general comment number 10, recommends the UK bring its juvenile justice into line with the Convention on the Rights of the Child. And in particular, it recommends the UK, you see there at F, immediately, this will be 79F, the report, immediately remove all children from solitary confinement, prohibit the use of solitary confinement in all circumstances, and regularly inspect the use of segregation and isolation in child detention facilities. Now, what the Court of Appeal said about that is at paragraph 96. It didn't appear to attach any weight to that because 96, you see it says once again, it says that about a number of reports, but this is a recommendation for future action, not a statement of current law. And therefore, as we understand it, no weight was attached to it in terms of interpreting Article 37 of the UN Convention on the Rights of the Child. And our respectable submission is that is a misunderstanding of how one takes these sorts of reports. These are reports on individual countries that the Committee on the Rights of the Child produces. All of them are framed as recommendations for future action. That is the nature of these reports. And you can see why from Rule 75 of the CRC's Rules of Procedure. I don't think you need to turn them up. For your notes, it's page 1026 in tab 6 of the Primary Authorities Bundle, is all of these sorts of reports about individual countries are recommendations. They're general recommendations made by the committee to individual countries. So I say they're invariably framed as recommendations for future action, but that does not stop them being, and has not stopped them being in domestic authorities, taken as setting out the authoritative view of the committee as to what is required. And you can see that most clearly in the Williamson case, which is the corporal punishment case. It's a case about a challenge to the UK's prohibition on corporal punishment. And I won't take you to it, but for your notes, it's page 1524, paragraphs 82 to 86 in Baroness Hale's speech. And Lords Brown, Walker and Lord Bingham agreed with her. She sets out there various CRC committee reports about the UK in which it made recommendations to the UK and expressed concern about the use of corporal punishment in exactly the same terms, or if anything weaker terms, certainly recommendations, as was the 2016 report we were just considering. And it's in that context that she said this sets out the authoritative view of what the UNCRC requires, at paragraph 86. And so we do say that it was an error of the Court of Appeal to assume, because these were recommendations, that is not the committee setting out its authoritative view. It is. That is one of the ways. General comments and individual state recommendations is where the committee sets out its views as to what the Convention requires. And it is unequivocal, we say, in relation to the UK, that the UK must immediately remove all children from solitary confinements, specifically noting it's a practice that's used in young offenders institutes and must prohibit its use. And the clarity of the CRC position is further confirmed in the latest general comment, which came out after the Court of Appeal handed down judgment. It came down in September 2019. And you have that at tab 8 of the authorities bundle, primary authorities bundle, page 1054. And you'll see in the first paragraph, it explains that the present general comment replaces, this is page 1055, paragraph 1, replaces general comment number 10, the 2007 one. As a result of the promulgation of international regional standards, the committee's jurisprudence, so that's its other reports and other country reports, new knowledge about child and adolescent development, and evidence of effective practices. It then deals at 1068. You'll see under the heading Treatment and Conditions, Article 37C. So here it's giving its understanding of what 37C, which is the provision dealing with children deprived of their liberty and the requirement to treat them with respect for their inherent dignity. And you see 95, the committee emphasises that inter alia the following principles and rules need to be observed in all cases of deprivation of liberty. And you'll see G and H deal with solitary confinement. G deals with the disciplinary measure point. And we say it's quite clear from this text that the committee's view is that solitary confinement is a practice which constitutes a breach of Article 37, and therefore that is why it is forbidden as a punishment. You see that the second sentence, disciplinary measures in violation of Article 7 of the Convention must be strictly forbidden. So it lists things which are in violation of Article 37, and they cannot be used as punishment. It then sets out other matters which also cannot be used as punishment, but which don't themselves breach Article 37. So, for example, depriving a child of bedding, that is not going to in itself constitute a breach of a violation of Article 37, but you can't use it as punishment. So we say it's quite clear there, as it was before, that the reason you can't use solitary confinement as punishment is because it's not consistent with Article 37, it's in violation of it. And it's then made even clearer, we say, by G, which has been added, that it's put simply, solitary confinement should not be used for a child. Then it deals, by contrast, with separation, which, as I said, everyone accepts can be committed, but not solitary confinement. So it's clearly they're talking about any circumstances, and that fits with what it said to the UK, calling it through to immediately cease the hold children in solitary confinement in young offenders institutes and more generally.
Mr. Squires, before you move on from this, could I just ask a quick question? This is a 2019, I think, elaboration of the principles applied by the committee. We're dealing with a case back in 2016. There seems to be a process, as often happens, of development of standards. What do you say is the proper use for us to make of this sort of material post-dating by a few years the particular facts of our case?
Our submission in this case is that this simply reflects the earlier position. And the reason we say that most clearly is because you see what is recommended in relation to the UK in 2016. So it is correct, and my lord is absolutely right, and that was said in the first paragraph. This is in recognition of developing standards, but it is clear we submit that in 2016, what the views were of the committee in relation to solitary confinement, specifically in relation to the practice in young offenders institutes in the UK. And we also, our submission was that in fact, this does, at least for these purposes, general comment number 10 is essentially saying the same thing as it's elaborated in this general comment.
Yes, thank you.
My lords, the question then is where does that leave us? As I say, these are not binding, the views of the committee, but they are, we respectfully say, authoritative views. And
just before we leave it, Mr. Squires, it may be, I know you're focusing on solitary confinement, but there are other points made in this paragraph which may be relevant to our case as well. In B, the need for due regard for the need of children, sensory stimuli, opportunities to associate, participate in sports, PE and leisure activities. C, importance of education. And you don't necessarily have to rely on the CRC for this. Article 2 of the first protocol would cover the need for education. And one might have thought that that and the points made in B were part of what one would regard as a humane treatment of children.
Well, yes, we would certainly accept that it is all relevant. I mean, it's notable that this is all about 37C. This is all about how the committee thinks one should treat children with respect for their inherent dignity. And we'll see in a moment that that's critical to Article 3 as well. The notion of dignity underpins Article 3 as well. And we would absolutely say that giving a child education, meaningful activities, etc., is all part of recognising, of treating a child with dignity. Where it steps into solitary confinement, which is a complete absence of any of those sorts of activities, coupled with confinement in a cell for, in our case, over 23 hours a day, and we say that then steps into degrading treatment for the purpose of Article 3. But by law, we certainly accept that it is notable that all of those come within.
I don't want to be critical, but I think it's important not to, in a case of the present kind, for us not to be solely focused on solitary confinement and authorities concerned with that. There is no Strasbourg case, as far as I know, that concerns the concern solitary confinement of children. And equally, there are very few Strasbourg cases concerned with Article 3 in relation to children. And those that there are have mostly been to do with sexual abuse, I think. The state's failure to protect children against that sort of degrading treatment. So it may be we're looking at a case where if this went to Strasbourg, they would be really, they wouldn't find any precedent in their own case law that was really on point. And they would then, one would have thought, be thinking about, they would obviously take seriously international law standards, and they would look at the practice of the member state, of the contracting state. And I'm not sure that that what's been said in their case law about solitary confinement would really be all that relevant.
You slightly faint with the last question.
Yes, I'm just sort of. It just strikes me that we need to have very much at the forefront of our minds that this is a case about a child, and that may differentiate it from consideration of solitary confinement in other contexts.
But no, we respect, again, of course, this is all about, these reports are all about solitary confinement of children. And it's absolutely right, all of these different bodies, obviously the UNCRC is only concerned with children, but it is only here concerned with solitary confinement children. All the other bodies I showed you, some of them are concerned with, and this will include, I'll come into a moment, the Committee Against Torture is concerned with adults as well. All of them make clear that children are in a different position. All of them say that have considered it should be prohibited for children, all of them say adults should be exceptional, etc., but none of them say it should be prohibited. And we say, my lord, precisely it is because of the recognition of what it is to treat children in a way that is not degrading, consistent with their dignity, which does include education, meaningful activities, the whole gamut of things, which also form part of what is solitary confinement, is the absence of all of that. And it's because it is recognised that children, for those purposes, are different to adults that you see this.
Yes. Yes.
I was just going to give you the references to the Committee Against Torture reports. They're set out in our, in fact, they're set out in our printed case, paragraph 45 and footnote 7. And what one sees from those reports, we've given 3, is that the Committee Against Torture has that same view, which is maybe acceptable for adults in certain circumstances, but in relation to those various country reports, it calls on the various countries. It said it should not be used for children, should be prohibited for children, should be abolished for children, is the repeated view of the Committee Against Torture. And it is clear from those reports, particularly the one for the USA, that it is not talking about only punishment. They make clear they're talking about also for protection, health-related reasons. So again, it's the same point, is recognition about the differences of children. The next question is then, where does that leave us, if it is correct, as we say it is, that is the authoritative view of what the various international treaties require? What does one then do? Well, what one is required to do, as we saw from Eulinger, Demir, and the various domestic authorities that applied them, is take into account those treaties, or what the treaties require. And again, I think we're in agreement with the Secretary of State as to what that means. It's in his printed case, paragraph 42, page 136. And what the Secretary of State says in that paragraph is it requires an interpretation, or the purpose, he says, of the interpretive approach for taking into account of it is to avoid conflict or fragmentation between the European Convention and other international instruments. We respectfully agree with that. And there's then a quote from C, in turn quoting X and Latvia. And again, what that makes clear is that what one attempts to do is to avoid conflict between different international treaty obligations when one is interpreting the convention. One seeks to harmonise, as far as one can, the different conventions. And I'll come on to what that means for this case when we look at Article 3. My lords, in terms of, that's the hard international law position. We say, as I say, there are provisions that are clearly relevant. We would invite the court to accept the authoritative views are the correct ones of what the convention requires. What one then has to do, I say, is take it into account, i.e. read in harmony with, when one looks at Article 3. In terms of the soft international law provision, so this is the views of the various domestic bodies, and perhaps more importantly, at least in Strasbourg terms, the views of bodies like the CPT. What the Court of Appeal said about those, we've already seen what it said in relation to the CRC, which was these were just recommendations for future action, not a statement of current legal principle. And the committee, the Court of Appeal said the same thing about a series of the different international domestic documents we relied on. They said the same thing about the Istanbul Statement, the same thing about the NPN. That's a paragraph 92 of the Court of Appeal, Istanbul Statement, paragraph 83. And again, our understanding is, certainly it appears from the judgment, the court therefore didn't give any weight to those views because it regarded them, as I say, as merely recommendations, not statements of current legal principle. And our respectful submission is that's not the correct approach. These various bodies, when they give their recommendations, are not purporting to give statements on current law. What they are seeking to do invariably is make recommendations for future action. That is the nature of what these bodies do. They're not legal bodies. It's not, I think the JCHR, I think, has include Lord Wolfe and other lawyers, but it's not, most of the others, and the JCHR itself is not purporting there to act as a legal body. The reason that their views are important, we say, is in the Stradbroke jurisprudence is twofold. One is whether they show an international consensus, and particularly a European consensus, and that's why the CPT is so often focused on. Secondly, we say it must also be relevant when one is considering whether treatment infringes, doesn't respect, interferes with the child's dignity, which we'll see as the underpinning concern of Article 3. It must be relevant to that such a wide range of bodies specifically concerned with the penal system, health, children's rights, all of them reach the same conclusion that is acceptable for adults, but never acceptable for children. So we do say the fact that all those bodies reach that conclusion, whether it's because they're concerned about long-term psychological harm, which you see in the medical bodies, whether it's simply regarded as an inappropriate way to treat children precisely because the need for education, the need for social contact, the need for meaningful human engagement means that is an unacceptable, inappropriate way to keep children. All of that, we say, is relevant to the exercise that the court is then engaged in when it interprets Article 3. And in response to my Lord Reid earlier, in relation to whether there are things as close to a CPT finding that we have here specifically about Article 3, we think we may have found something, but it may be something I'll look at over the short adjournment, a similar example of that. But what we do see throughout all of the cases, and we cite them, paragraph 95 in our 95 and 96, is repeated reference to the CPT's views about prison conditions as at least guiding, not binding. There are times when undoubtedly the court will depart from them, but certainly when you have their views expressed, and particularly when, as here, they fit so closely with what all other bodies consider, our submission is that certainly Strasbourg would give weight to it, and our submission is that the same should apply here. Turning then to Article 3, as I say, the issue with all of the international hard and soft material and domestic is how should that then influence the interpretation of Article 3? So I wanted to turn next to Article 3 and deal first with the strict necessity argument. And the question is it, are we correct that at the very least, if solitary confinement children is ever permitted, if we were wrong on the per se degrading treatment, is it at least prima facie degrading treatment such that, unless it can be shown to be strictly necessary, used exceptionally, it will breach Article 3? And as I say, the Secretary of State's position is they dispute that as a proposition of law. So they don't dispute that wasn't the test applied. They don't dispute that if it was, it wouldn't be met. But their submission is that it's not a strict necessity. It's certainly not per se degrading, and they say it's also not something that requires strict necessity in order to be lawful. But paragraphs 112 to 114 of our printed text, and then 123 to 125, we set out general principles about the strict necessity test and the kinds of circumstances when it applies and the nature of the test. I don't think that's disputed. I wasn't going to take you through the various authorities, but just to say, but to make, if I can, what we say are four, I hope, uncontentious points about the application of the strict necessity test. The first is that Article 3 is, of course, an absolute right, but there are circumstances recognised by the court, by the Strasbourg Court and domestically, in which certain treatment will breach Article 3 if it's not strictly necessary. But if it can be established it's strictly necessary, treatment of a last resort, etc., it will be lawful. Well, he said it won't breach Article 3. Second, the way in which the strict necessity test appears to be applied is that when one has treatment which is prima facie inconsistent with a person's dignity, or it runs the risk of causing them harm, significant harm, it may be strictly necessary to impose that kind of treatment, something that's prima facie incompatible with dignity, runs the risk of harm, if it is strictly necessary to protect the person themselves or to protect other people. But if it's not, if one otherwise has something that I say is prima facie inconsistent in that way, it will breach Article 3. Third point is that where a strict necessity test applies, it is quite different from a normal proportionality balance. It is quite different to, for example, an Article 8 case in terms of what one's weighing. And various different phrases have been used to capture a strict necessity test, and we set those out in our paragraphs 123 to 124. The courts have described the test as being something that's indispensable, established ultimate necessity, convincingly and compellingly demonstrate a last resort. All other options, reasonable options, have failed. Exceptional. That's what the court's intending to convey, we say, when it applies a strict necessity test. Fourth point that we get from the authorities, which we'll see in a moment, is that in order for a detaining authority to be able to ensure measures are only taken when strictly necessary, and moreover, in order to be able to convincingly demonstrate significant strict necessity after the fact, there will almost certainly need to be procedural safeguards in place. And we'll see that in the Strasbourg authorities. We've also seen that in many of the bodies that have considered specifically the solitary confinement of adults and the separation of children. Because at certain points, the Secretary of State characterises our case, this is paragraph 99 of his printed case, as being that if there's any breach of a procedural requirement, therefore the detaining authority would fail the strict necessity test. That isn't our submission. The position we say on the authorities is that if you don't have procedural requirements to both ensure strict necessity and to be able to demonstrate it after the fact, it will be very hard to convincingly, compellingly show that the requirement has been complied with. If you don't have some sort of process whereby someone has to sit down and make a decision and record that decision, it is very likely that you will be unable to ensure strict necessity, and certainly you will be unable to prove this afterwards. And we'll see a demonstration of that in the Appellant case, a Danish case about the restraint of a patient. Turning now to the authorities on a strict necessity test, which we say by analogy are going to apply to the solitary confinement of children. We'll also see what is specifically said about the solitary confinement of adults. The first case that we rely on is the Bouillid, if I pronounced that correctly, the Bouillid and Belgium case, which is in tab 25 of the authorities.
Page number?
1714. 1714 it begins. And the case is about two brothers who alleged they were slapped by a police officer during an interview. One was 17 at the time, so a minor, and you'll see there's some things that the court says about that. Paragraph 86 to 90, page 1738. The court sets out from 86 down to 90 some general principles. I don't know if, if the court hasn't looked at it, it would help just to glance over those 4 paragraphs. And what we say one gets from that is that paragraph 86, it's often recited in the Strasbourg jurisprudence, must attain a minimum level of severity. But then it explains it in 87 that usually involves actual bodily injury or intense physical or mental suffering. However, even in the absence of that, and it's particularly we rely on treatment showing a lack of respect for or diminishing a person's human dignity, that can engage Article 3. And that's again why I emphasise the Article 37C of the UN Convention on the Right of the Child. It's the dignity provision that the committee was particularly concerned with in this context. And that also underpins Article 3. And it's the court then goes on, it then sets out the provision on strict necessity in relation to the physical use of physical force. So if it's used and it's not strictly necessary by the person's own conduct, that diminishes human dignity. And it doesn't matter in that context what level of pain the person has suffered. Unless it's strictly necessary, any imposition of physical force undermines dignity and is inconsistent with Article 3. And the court at 90 explains the connection between degrading treatment and dignity in the convention. And our submission will be, I say this is applying physical force to a child, but our submission will be, or physical force to an adult or child, but our submission will be, that also applies, it is also a diminishment of a child's dignity to be kept, to be locked alone in a room over 23 hours a day without access to meaningful contact, education, etc. So at the very least, if it's ever acceptable, it needs to be strictly necessary. Paragraphs 101 to 102. I apologize, 100 and 101. It's again the connection between dignity and Article 3, and in particular stressing that any physical force in that context doesn't have to lead some particular level of harm, will, if not strictly necessary, breach Article 3. Paragraphs 109 to 110, which is 1742, deals with the fact that one of the applicants was a child. And again, it may help just to glance over those two paragraphs, 109, 110, and 1742. And there's there a recognition of the greater impact measures will have on children. Reference to the international law position, I think in the footnote, it's referring to the UNCRC and other international materials, and the recognition that conduct which may not breach Article 3 for an adult may do for children. And of course, our case is slightly different because in this context, any use of force on an adult or a child in detention will need to be strictly necessary. So here a breach was found both in relation to the 17-year-old and the 25-year-old. But we do say the recognition of the difference between children and adults is important because in our context, there is a marked difference, certainly in terms of what all the different international and domestic bodies say, between adults and children as such. So it's specifically said as acceptable for adults in certain circumstances, but never for children. So that maybe brings out in greater contrast the difference that the court here is alluding to between Article 3 measures if the alleged victim is a child or an adult. The next case, and I'll make submissions generally about what we get from these cases shortly. The next case we run is the Agerholm case, which you have tab 22, page 1527. And this case shows a number of things. Firstly, how the strict necessity test is applied to the restraint of a patient.
Just before we, I'm sorry, Mr. Krause, just before we leave it, I mean, that last case is there's quite a significant passage in paragraph 53, which is 1729. No, 1729. It's just before we leave the case.
Yes.
Because this is a Grand Chamber judgment concerned with Article 3 in relation to children, and there aren't that many of those. And in paragraph 53, they refer to the Council of Europe recommendation on European rules for juvenile offenders, which we haven't looked at. Another recommendation which emphasizes children's fragility and vulnerability and dependence on adults for growth and development, which they say underlines the extreme vulnerability of juveniles deprived of their liberty. And then they refer to a CPT report, which indeed they've previously, earlier in this, they've also referred to other CPT reports. One sees the approach that they're adopting. So this has been quite a lengthy section to do with international, European and international materials, which starts back in paragraph 45, and includes the UNCRC.
Yes, but yes, paragraph 48 is the CPT, and this may be another example actually of the CPT making findings about certain types of behaviour. But paragraph at page 1058, 1727, paragraph 126, I see of a CPT report, or CPT standards, talks about corporal punishment likely to amount to ill treatment and must be strictly prohibited. So that may be an example of the CPT, and certainly see that later on in the Strasbourg jurisprudence. But my Lord, absolutely, it may be that we will try and chase down possibly some of these other references to see if they do assist. Certainly, the general principle, the recognition of the particular vulnerability of children, and even more so, the vulnerability of children who are in detention, we say all ties into our arguments on degrading treatment, recognition of dignity, and it runs through all the international materials. But we'll certainly see if there is more helpful or relevant material in some of these reports.
Yes. Yes.
And of course, it was 52 and 53. I think that the court was referring to in its 52 and 53 when it's in paragraph 109. 1742, when it talks about the difference between adults and children, the need to take account of the vulnerability of minors has been clearly affirmed at the international level, and that then takes us to the footnote, takes us to 52 and 53. My Lords, I was going to turn next to Agerholm, and actually we see a very similar pattern. This is a case about patients, and we'll see actually a very similar set of concerns about patients in detention that one sees about children in detention. And we do say that that's, as my Lord said, there's not a great deal of cases about children in detention.
The recommendation document, I've just brought it up, the recommendation number 11 of 2008 is, I think you may find it's directly relevant to this case. You might want to look at it over the short adjournment.
But we will. But I guess we'll chase that and the other ones as soon as we can. Agerholm, you have it at 1527, tab 22. And what we see here is the approach that the Strasbourg courts take to patients in detention. And the case is about restraint of a patient, but we'll see that the court also talks about and relies on international material that deals with the seclusion of a patient, which is locking a patient in a room. It is generally regarded as not being appropriate to leave patients in solitary confinement, but it is a measure whereby patients are unable to leave a room. So certainly similar, and we'll see that the court's observations, as well as the international materials it rely on, all treat restraint of a patient in a very similar way in terms of the application of a strict necessity test to the seclusion of a patient. And our submission is that the analogy with solitary confinement of children is clear. The facts of the case are that it's concerned a patient who had been convicted of a crime but was then serving a sentence in a hospital, who is restrained by being strapped to a bed for a period of some 22 hours. And it's helpful, and this gives a further illustration of how international materials are dealt with, to see what the court says, or what the international materials it quotes from are at page 1545. You'll see the heading, relevant international and European materials, and the first thing quoted from is a UN General Assembly resolution. So this will be akin to the Mandela rules, the 1990 juvenile detention General Assembly resolution that we've seen in our case. This one applies to people with mental illness, protection of persons with mental illness. And what my Lords will see at principle 11 we'll see this principle is that physical restraint or involuntary seclusion of a patient shall not be employed except in accordance with the officially approved procedures of the mental health facility, and only when it is the only means available to prevent immediate and imminent harm to the patient or others. And we'll see that similar recommendations then feed through in various other bits of international, which you will see paragraph 55. This is a Council of Europe Committee of Ministers recommendation. Article 27, you'll see again a similar, firstly, treating seclusion and restraint in the same way, and secondly, imposing the same kind of test in relation to them, imminent harm, etc. And you also see, again, another theme that we'll see appearing is the requirement for procedural safeguards. Regularly monitored, reasons recorded, etc. And you'll then see a CPT report about restraint, but also, again, treating restraint and seclusion in the context of patients, at least in a similar way. You see that paragraph 50. And again, the stress on procedural safeguards to make sure it really is strictly necessary. So every instance of the physical restraint of a patient, and then it gives examples which include manual control, physical restraint, but also seclusion, should be recorded. And then you'll see paragraph 43 of a 2006 report, again, measure of last resort, extreme action applied only in order to prevent imminent injury or to reduce acute agitation and or violence. The court, paragraphs 79 to 85, then sets out the generally applicable principles. This is page 1553. Starting on, and you'll see also how their views reflect that international view on what's required. You'll see paragraph 79 is again the what you often see recited in Article 3 cases, minimum level of severity. Then at 81, and we say this applies equally to children, is the recognition of the special vulnerability of mentally ill persons in its case law. And reference the vulnerability of the patient when considering whether treatment is incompatible with Article 3. And it may help actually rather than me read, if the court has read 82 down to 85, I'll make some brief observations on it. Or 81 to 85. And we'll see at 83, again, reference to vulnerability, position of inferiority and powerlessness, typical of patients confined in psychiatric hospitals, calls for increased vigilance. Nevertheless, it recognises medical authorities may need to take measures, but, last sentence, still have to be satisfied that medical necessity has been convincingly shown to exist. And then 84 essentially mirrors what is said by the various international bodies. Again, it's treating seclusion and restraint in a similar way, and makes clear that it must be last resort, this is the middle of 84, only means available to prevent immediate or imminent harm. And then at the bottom of the page, towards the end of 84, towards the end of the paragraph, again, it's the procedural safeguards that are critical. There must be sufficient procedural protection capable of demonstrating sufficient justification that the requirements of ultimate necessity and proportionality have been complied with, and that all other reasonable options have failed to satisfactorily contain the risk of harm to the patients and others. And then once you start the measure, you've also got to show that its continuation throughout the relevant period remains strictly necessary. And paragraph 95, 1556, it notes that those conclusions, or that approach, is consistent with what's said to be the unanimous views of the relevant international European materials. Unanimous view is restraint can only be used exceptionally, matter of last resort, etc. So that reflects the court's conclusion as to the appropriate test for the purpose of Article 3. What the court then finds, and I won't take you through it, but it may be worth glancing at, is that the initial restraint was strictly necessary, but it then finds a breach later on during the 22-hour period. And for the court's notes, if you're looking at it, particularly 112 to 114, page 1561, what appears to be the problem is that there was a failure of procedural safeguards. What the hospital was unable to show, particularly because assessments weren't made at the correct time by the correct people, or certainly weren't documented, the detaining authorities are unable to show strict necessity throughout. So again, that illustrates how the procedural protections work. If one looks at 114, the final conclusion, what it concludes is that it hasn't been sufficiently proven that the continuation and duration was strictly necessary. And that, you see from the paragraphs before, is largely because there aren't records indicating that someone has considered strict necessity at a particular time, or why it remains strictly necessary at a particular moment. That's the Agarhol case. Again, I'll return to what we say the principles are from that and the other cases and how they apply to solitary confinement of children in a moment. Third case, or third group of cases, is the solitary confinement of adult cases. Because our submission will be, even in relation to that, the court is applying, and the court has then applied when it considers how the general principles operate in particular cases, a test which is pretty much indistinguishable from a strict necessity test. Though we accept the word strict necessity aren't used in the adult cases, but they seem to be applying something that is pretty much the same thing. And the leading judgment, or the one that's most often referred to domestically, is the Armand and the UK case, which is at tab 23, page 1565. This is a case about, I'm sure well known to this court, it's about challenges to extradition to the US of those suspected of terrorism offences from the UK. And one of the issues was raised. They said there was a risk they'd be sent to ADX prison in Florida, or something, the Supermax prison, and there was there a risk they would be placed in solitary confinement. And they said that breached Article 3. And the court sets out at paragraph 205, which is at page 1625, or you'll see, starting at paragraph 200, you'll see the general principles, again, repeated across the Strasbourg case law, but particularly noting middle of 202, repetition and respect for dignity as being one of the things the state has to ensure. This, of course, is dealing with adult prisoners. Then sets out principles on solitary confinement. And it may be, because these are repeated, the courts hasn't had a chance to read, just a glance down 205 to 212. And it may also assist to read 213, it's about outdoor exercise.
Can I ask Mr. Squires, the strict necessity test is one, you've shown us it in Agahome in relation to physical restraint, and it's been used, I know, in cases concerned with prisoners also in the context of physical restraint. Is there any case where the test has been used which hasn't involved the use of physical force?
We haven't found one in those terms. As we'll see in a moment, these solitary confinement of adult cases apply something that is pretty close, and we say essentially indistinguishable. The only thing I would say about the Agahome case is it does also refer to, except it wasn't a seclusion case, certainly both in the court's judgment and in all of the various cases, international recommendations it referred to, all of them treat, in that context, at least for patients, seclusion and restraint in the same way.
There's one prisoner's case to do with solitary confinement, which I know of, which also involved physical force. And you can contrast the discussion of the use of force in that judgment, where they do use strict necessity test, and the discussion of solitary confinement in the same case where they don't. The case I have in mind is called Matthews and the Netherlands. It's another one you might want to look at over the adjournment, or yeah, you might want to look at it then.
But my lord, I apologize. I got the Netherlands. I didn't get the.
Yes. Oh, sorry, Matthews. Mattthews.
Oh yes, we'll certainly look at that. No, I think our submission is that we say one gets the test where we accept, or we haven't certainly found a case that applies it expressly. There is only the Agahome observations about seclusion, which I should say also appear in almost the same form in an earlier Strasbourg case, M in Croatia. It says, in fact, I think Agahome quotes from it and also refers to seclusion. I mean, our submission is that one gets there when one adds in all of the material about the particular vulnerability of children in this context, and everything that's said about the international materials. Ultimately, our submission will be, if it's not a per se degrading treatment, at the very least, I apologise, my lord.
Yes, thank you. So I was just going back to Agahome. I mean, you say that the materials referred to there equate seclusion and restraint, but it seemed to me that actually they drew a distinction between them if one looks at page 1547. And in particular, paragraph 43 of the 16th General Report, which is in the middle of that page, that seems to be focused very specifically on restraint. And I mean, it does seem that pretty clear that restraint is a much more intensive interference with a person than simple seclusion. One only has to think of locking someone in a room to calm down and then strapping them to the bed, which is what happened in Agahome. So I did wonder whether you're right to say that there was an equation of seclusion and restraint in these materials, even on the face of what it says in Agahome.
The only thing I would say about that model, it does seem, and I appreciate it's a different CPT report, but the CPT report above appears to define first every instance of the physical restraint of a patient, and then appears to include seclusion in the brackets as an example of physical restraint. But I accept, and I said we accept that physical restraint to that extent is different from seclusion, but our submission would be that would go into satisfying the strict necessity test. One will need to show it may well be a different level of strict necessity, or more would need to be shown, or the more, and in fact, one see it even in terms of restraint, the more restrictive a restraint. I think here is he was restrained in a much more, in a more severe way at the outset, and it's gradually loosened. Our submission will be all of that goes into a strict necessity balance, but our submission is that one ought to treat, well, certainly there's an indication here from these bodies that they consider both at least ought to be a last resort, both ought to at least be strictly necessary, albeit I accept there may well be a difference in what one would need to show to establish that.
Yes, thank you.
Yes, well.
If you go to paragraph 84 at page 1554, isn't that also limited to physical constraint, physical restraint?
They appear to be talking, 84, I mean, because this case obviously is a physical restraint case, what they do talk about, they do again refer them to the legal standards on seclusion and other forms of coercive and non-consensual measures. So they're certainly treating the general approach to seclusion and general measures to in this case, but I accept it is a physical restraint case at a whole, and as I say, it'll only be when we come to the adult solitary confinement cases that we say we'll actually get something very similar in the confinement context. But I accept I do need to, one needs to read all these cases together with the views expressed about adult solitary confinement, but also we would say the views of all the international bodies, in particular views of the Strasbourg Court and the international bodies about the particular vulnerabilities of children. And that's, of course, been specifically recognised in relation to solitary confinement. It may be, there may be other examples where you have such a bright line drawn by all the different bodies, but solitary confinement certainly seems to be one where it's a practice acceptable for adults in exceptional circumstances, etc., but never acceptable for children. We do say that is significant when one thinks of how to apply this body of jurisprudence to the position of children. The Ahmad case, you had the paragraph sets out the Strasbourg view of solitary confinement of adults here, and we rely on a couple of the passages. Firstly, the recognition, paragraph 207, 1626, that solitary confinement is one of the most serious measures which can be imposed within a prison, and recognition of the comments of the CPT about the concerns about the impact of solitary confinement, of course, in relation to adults. Then a recognition that it may be acceptable, hasn't laid down precise rules, but paragraph 212, we do say reflects something that comes very close to a strict necessity test when it's setting out the safeguards and the requirements that have to be met. It's the one at the bottom of page 1626. Solitary confinement measures should be ordered only exceptionally and after every precaution has been taken, as specified in European prison rules. And that comes from, quoted directly as a requirement for solitary confinement not to breach Article 3 from the Ramirez-Sanchez case, the Carlos the Jackal case. And our submission is that is pretty close to, and we see actually very similar language used in Agahan about every precaution has been taken. We say that is effectively, or certainly very close to, a strict necessity test. exceptionally after every precaution has been taken. And of course, there is then the stress on the importance of procedural safeguards in this context. And my lords will also see, before leaving at 213, the importance of outdoor exercise, which again is something else that ties in with the treatment here of this child. It's recognised here that even for adults, one would expect an hour a day to be outdoors. This is a child where it's recognised there are even greater concerns. And as we saw, there were days in which, well, every day he had to choose between a shower and a phone call or exercise within his half an hour. But in terms of what we'd say the significance of the case is, and they say we see this throughout the adult solitary confinement cases, is the stress on the exceptionality, every precaution taken. And what one sees if one looks at the adult solitary confinement cases where the court has found there not to be a breach of Article 3, all of them, the courts have stressed in terms, or certainly in many of them, I think possibly all of them, in terms, the exceptionality of the case. So the Ramirez-Sanchez case, you'll see it's the same. We don't need to turn it up, but I think it's in tab 36 of the supplementary authorities bundle. It's the identical test. Solitary confinement should be resorted to only exceptionally and after every precaution has been taken. And in that case, the court finds it is an exceptional case. That's the government's argument at paragraph 98, 3535, is that his regime was wholly exceptional, dictated by the fact that as a unique figure known to national brats of terrorism, there's a very particular danger. And the court accepts that. 125 refers to him being, as at the time, considered one of the world's most dangerous terrorists. And so the court goes through a process of applying that exceptionality test and found it was met in this case. And one thing I should say about this case is it's not clear that certainly under the definition now used that this would actually be solitary confinement. In fact, if one looks at paragraph 131 of the judgment, one will see that he's effectively seeing his wife, who's also his lawyer, I think almost every day. I think he sees her 640 times over 4 years, except so it's a quite, and he's also out of his cell for at least 3 hours a day. But in any event, he's there for a very long time. But what the court stresses is the exceptionality of the measure applying that test. I see the time. I don't know if this would be a convenient place.
Well, if that's a convenient moment for you, Mr. Squires, then by all means, we can adjourn now and resume at 2 o'clock. Thank you.